Welcome back. As you know, we just discussed that the source of law in the United States is the U.S. Constitution and the state constitution. But also, our law comes from federal and state statutes, ordinances, administrative agency rules and regulations, executive orders, and judicial decisions by federal and state courts. That's the basis of our case law. Now, we talked about the purpose of law, but let's talk about the functions of law. The functions of law is to keep the peace, shape moral standards, promote social justice, maintain the status quo, facilitate orderly change, facilitate planning, provide a basis for compromise, and maximize individual freedoms. Now, when we talk about law and its functions, we need to understand how it works. Our legal system is called an adversary system. Now, this comes from the English, and as we'll discuss later, that our legal system is based on the English legal system. Now, the adversary system holds that out of the struggle of ideas emerges a certain truth. I want you to underline certain truth. Notice I didn't say truth. It should be noted that in our lives there's only one absolute truth. That truth is, if you live, you shall die. All other truths are relative. People say, if I hit the lotto and win millions of dollars, I'll be happy. Well, you could hit the lotto, win millions of dollars, and still not be happy. People say, if I meet the right person, I'll live happily ever after. Well, you can meet the right person and still not live happily ever after. But the only ultimate truth for us is that if you live, you shall die. So when we say that ours is an adversary system and that our system is based on the struggle of ideas emerges a certain truth, it's a recognition that there's no absolute truth. Therefore, sometimes, as I pointed out earlier, sometimes innocent people are found guilty. Sometimes guilty people are found innocent. Sometimes the wrong people win cases and the right people loses cases. Okay? So we say that the trial, a struggle of ideas, is essentially A versus B. A being the plaintiff, which we will describe later, and B being the defendant. When these two struggle, there's only three possible outcomes. Either A dominates B, or B dominates A, or there's a compromise. Now, in order for this to work, for this system to work, this adversary system, then most parties must be relatively equal. In other words, both parties have to have the right to present their point of view, their idea. Now, we know in this world it's not equal. Some people have more than others. Some are smarter than others. Some understand things better than others. But for this system to work, it must make the parties relatively equal. We say that we make the parties relatively equal by what is called the due process rules. The due process rules are an essential part of the Constitution. What are these due process rules for us? The first is called notice. In other words, how can you defend yourself unless you know what you're accused of or what you're charged with? In a lawsuit, we accomplish notice with what is called the summons and complaint. Now, the second due process rule is called opportunity to be heard. In other words, if someone makes a claim against you, then you have a right to be heard. In a legal action, this is called an answer. In other words, you're answering the complaint of the plaintiff. Now, some people cannot speak for themselves. Some people need someone to speak for them. So our next due process rule is called the right to counsel. In other words, a right to have someone advocate on your behalf. Now, many people don't understand what a lawyer is. A lawyer is simply an advocate. And this is why it's so difficult for people to become lawyers. Most people can't advocate or argue for something unless they believe in it. A lawyer's duty is not necessarily to believe in it, but believe that everyone has a right to be heard. Therefore, an advocate. So many people misconstrue a lawyer because they think, well, how could you represent that person? That person did horrible things. Well, it's the job of a lawyer to advocate because everybody has a right to be heard. Now, there are other due process rights. For example, in criminal cases, you have what is called the right against self-incrimination. Most of you know it as your Fifth Amendment right. In other words, you cannot be compelled to testify against oneself. Now, in a trial, we have what are called actors. Because we say that a trial or a legal action is theater of the real. What do you have in theater? Well, in the theater, you have actors, you have a plot, you have the highlight, and you have a conclusion. Well, in our theater, our actor, the first one is called the plaintiff. The plaintiff is the party who initiates or starts a legal action. What you should know, and please keep in mind, is that generally the plaintiff has the burden of proof. Under our system, if you make an accusation, you must prove it. Therefore, the plaintiff generally. Now notice that I said generally. Whenever you see words like generally, then you know that there are exceptions. Our second actor is called the defendant. Who is the defendant? The defendant is the person defending or denying. Generally, the defendant can defend with, please note this, number one, a general denial. A general denial simply says, I didn't do it. Number two can answer with a specific denial, which says I did A, but I didn't do B or C. And number three, and this is important, the defendant may assert what we call an affirmative defense. When the defendant asserts an affirmative defense, the defendant admits guilt or liability, but seeks to be excused under some rule of law. Most of you are familiar with the most common affirmative defense is self-defense. In other words, I killed him, but I was justified in doing it. Okay? Now, this is important. When the defendant asserts an affirmative defense, the burden of proof changes. In other words, The defendant now has the burden of proof. Remember, I told you that generally the plaintiff has it, but this is the exception. Now, when we go to trial, please note that the jury determines questions of fact and the judge determines questions of law. Now, how does the jury determine questions of fact? Well, they determine it by what is called evidence. Now, put this, evidence is that which is presented to the trier, T-R-I-E-R, of fact, put in parentheses, jury, to determine what had happened. Evidence may be, number one, testimonial. Number two, documentary. Number three, physical. And four, circumstantial. Now, this is important. Evidence is a species of proof, not proof itself. Evidence leads us to a certain truth, but is not truth in and of itself. If we look at evidence and you read it, if you look at the lawyers consider the best evidence for them, especially if you're on the defense, is testimonial evidence. The reason being is that we see what we want to see. If you look in your book, you'll see the essay on "I thought I was right, but I was wrong." In other words, we have cases where people think that they see something and they actually did not. Or what they saw is what they believe they saw, not what they actually saw. Documentary evidence, physical. Circumstantial evidence is evidence gathered from the circumstances. Now, it's important when you look at evidence that you look at it objectively. The most dangerous thing is assumptions. When we make assumptions, then we ignore facts. And when we ignore facts, we can't reach that certain truth. So now we know about our trial adversary system. Now let's go back to Regina versus Dudley and Stevens. Hopefully you read it and you've discussed it and tried to understand it. But if you were to be logical and reasonable, before you read that case, what was the first logical thing you should do? Well, the first logical thing you should do is learn how to read a case. I told you that in law school, we don't use text. We learn the law by reading cases. So how do you read a case? Here are the rules. Number one, the first thing you do is identify the parties. Notice in our case, the case is Regina versus Dudley and Stevens. First of all, who's Regina? There was no woman on that boat. And there's one person missing. Why? The second thing you do is distill the facts. Now, what does it mean to distill the facts? In other words, to look for only those facts that are relevant to our next thing, which is called the issue. The issue in our case is, did these men commit murder? In other words, you're only looking for those facts that go to murder. Well, how do you determine murder? Well, you have to know what murder is. So the next logical thing is you look up murder. which is called the rule of law. Now, what is murder? Murder is the unjustified taking of life with premeditation, which means intent, or killing by poison. So if you look at our case, you apply this rule of law to the facts. Once you apply the rule of law to the facts and the issue, you reach what is called a conclusion or judgment. Therefore, you reach a conclusion about whether or not these men are guilty of murder. It's important to look up the definition of murder. You can't call something something unless you know what it is. Not all killing is murder. People die every day, but it's not murder. Sometimes people die by accidents. Why isn't it murder? A life was taken. So you have to be precise about what you're looking up. So please reread the case, follow the rule on how to read a case, compare the facts, and at some point we will discuss your conclusion. The other thing is to read the 3 theories of law. If you read the 3 theories of law, then you can say that under one system or one theory, these men would be guilty of murder, and under another system, these men would not be guilty of murder. Please read, and we'll see you next video.